year, the selected candidates would be entitled to seniority. Now, this judgment I have quoted, but I must point out immediately here, in this judgment, the fact was that all three streams joined in the same year, 2007. And therefore, what this court says, para 67, the court has, however, taken the view that date of joining is not relevant, 2007. And therefore, what this court says, para 67, the court has, however, taken the view that date of joining is not relevant. Para 67, officers belonging to different streams have to be confident that they will be recruited under their quota and get seniority as per quota and roster. In the event seniority is to be fixed with date of joining of particular stream, it would lead to uncertainty and making seniority dependent on administrative authorities, which is neither in the interest of service nor serves the cause of justice. We thus conclude that roster is fully applicable for determination of seniority. Officers of different streams selected in a particular year, even though they were allowed to join the post on different dates, shall not affect their inter-se seniority, which is to be decided on the basis of roster. So this is what the court has mandated. Otherwise, my lord, I should not finish this point without stating this Punjab and Haryana High Court relies on Parmar's case. Now, Parmar's case in Megha Chandra was said to be not good law by 3 honorable judges. Subsequently, a bench has referred Megha Chandra to a larger bench saying that no, Parmar is good law. Those 3 judgments in a compilation I will hand over to your lordships, my lord. But that is the factual position of the Parmar. That larger bench is pending, but your lordships is in that larger combination, and that may not hold your lordship's hands in taking whatever view your lordship feels is the correct view. And especially, we will make it small. I will just put those 3-4 judgments together and then pass on to your lordships in a compilation.
On what point?
Pardon me?
In Parmar,
Megha Chandra said, you cannot get seniority from a date before which you are born in the cadre.
right.
Parmar said that date of occurrence of vacancy and initiation of process or issuing advertisement is the relevant date. It will relate back. Parmar is those income tax officers, my lord, case. So Megha Chandran, relying on the subsequent judgments which said seniority can only be from the date you actually join the service, you cannot get earlier, said Parmar does not lay down good law. Then, but in a later combination, Justice Oak had actually referred it to a larger bench saying that no, Parmar does lay down law is correct and that reference needs to be relooked at. So that is where Parmar stands today.
Reference by decided by 3 judges.
Yes, references by 2 honorable judges, my lord. References by 2 honorable judges, and it is referred to a larger bench which is still pending.
The Nykaa Pink Friday sale is now live.
So that is where Parmar stands today.
Reference by decided by 3 judges.
Yes, references by 2 honorable judges, my lord. References by 2 honorable judges, and it is referred to a larger bench which is still pending. We pass the following order. We are of the considered view that following questions need to be decided. Whether the decision in the case of Megha Chandra can be said to be a binding precedent in the light of law laid down by the Constitution bench in Mervyn Contino and the law laid down by coordinate bench in Subhash Reddy. Then this exactly what that Parmar is right. This is what has been referred. So it will come before 5. That will not hold your lordships back. While looking and considering and reconsidering, the only problem in this seniority on roster is if one process gets unduly delayed, then the problem comes. If it happens within the year, there is no problem at all. It is the best way forward because then you are giving all 4 categories a representation in every block of 4 because roster is 2, 1, 2, 1, 2, 1, 2. It will go on. And in case vacancies are, promotees are more, they will bunch below for that year. And next year, a fresh roster will be there. Fresh seniority will be maintained. But the only problem is if there are 2 years, 3 years delay, as in Delhi, and promotees come, that if your lordship will take care of that, and according to me, there can be because your lordship is focusing now on judicial services and removing imbalance in judicial services. So some framework, some scheme, some could be made by your lordships, my lord, in this combination, that the delay is minimized and does not in any case exceed 1 year, because that 1 year's buffer is there. Next year select list at the earliest will come into existence in September of the next year. So even if a process is delayed by 1 year and completed before September of the next year, still this can work. This system can work, and it will give a good result, my lord, if it works. Because so, my lord, this is my submission on quota, and this is actually my solution also, my lord, before your lordships. Now, roster. Now, my lord, so far as quota is concerned, the next point on quota, my lord, the point is that quota is really, the Lokinath says it, on source of recruitment, it's not possible. I mean, so therefore, my lord, if your lordship just wants to make a note on the side of it, the crucial 2 paras of the Lokinath are at page 789 of the judgment as it is presented before your lordships. It doesn't have paragraphs. It is page 49, at page 49 of volume 5A. Otherwise, my lord, in the SCC judgment, if your lordship would look at the SCC citation, the relevant paras are 45 and 46. But my lord, so far as Delhi is concerned, my clients whom I am representing, and therefore in quota we have put our second point. We are very happy with the amicus's suggestion. While pointing out that this perhaps is not judicially possible, then what I have said is, alternatively, it is submitted that in the event this court comes to a considered decision that it is necessary and required for a quota to be provided, then, my lord, our submission is what the amicus is saying. 1:1, he is saying, we are quite happy with that.
Atwalya, what is your response to Jagannath?
To
Jagannath versus Union of India, 1992 supplement to SCC 105, paragraph 45 of the amicus's brief.
para 45 of the amicus's
Brief. That is one case where Tirauke is considered, and the experience is taken as a parameter for classification.
Huh?
That's the only case where experience has been taken.
Page 45.
Paragraph 45.
Para 45. In Jagannath, Lord, yes, there also, my lord, in fact, it is, the facts are totally different. The facts of Jagannath are totally different. Just pick up this idea. Huh? It's at page 292, at 296. In fact, this is a lot of compositors working in government presses and the relief. These are totally different facts in which those observations are made. In fact, it's very crystal clear in more than one occasion, and this is on pay scale. If your lordship will see, it is obvious from the recommendations of the committee that highly skilled category was created to handle nature of work which involved higher skill. The compositors with longer service who were found fit for promotion were appointed to grade 1 and categorized at highly skilled. Since merit, there is a valid basis. This is, my lord, this is different. It is on some merit and skill.
The subclassification.
Correct.
And the parameter, the object, and the subclassification on experience was held to be a good rational nexus.
But here the experience is the same for everybody,
Right.
Lord, because here we are all part of the same cadre. Here you are doing the classification.
Your case here would be that the experience here is of the district judge entry level.
Correct.
And not the experience prior to.
Correct. And therefore, you are now going to classify them on the basis of their birthmark, their source of entry. That is held to be not valid at all.